enough justice in my last video that I posted. The video, if you haven't seen the video that I posted right before this one, you might want to go back and look at that one. Before, because this is pretty much almost a part two. I'm kind of digging in a little deeper about equity. When it comes to using a habeas corpus, petition, I want to look into this type of stuff. I should have put on my other little. Oh yeah, I think I got it pulled to the side. I'm gonna kind of. Of course, y'all know I'm looking in the Georgia codes, and I'm gonna read a couple of these things where they're talking about equity. All equity jurisdiction here. This is Georgia now, so you got to read your own state statutes to find out where equity jurisdiction is can be invoked in what courts in your state. Okay, all equity jurisdictions shall be vested in the superior courts of the several counties in the Georgia statewide business court. Business. Anyway, as provided in Code Section 15.5A3. Okay, just to let you know, it's all in Superior Court. That's where equity all equity jurisdiction shall be vested in Superior Court. This is also where a petition for a writ of habeas corpus has to take place as well. I think I showed y'all that before as well, but I'm gonna move forward. Let's go. I want to show this one right here. Say grounds for equity jurisdiction is established. What I read to y'all was Title 23, Chapter 1, Article 1, but this is Article 3. I skipped 2. Okay, so I just kind of put to the side what I wanted to, present today. Equity jurisdiction is established and allowed for the protection and relief of parties where, from any peculiar circumstances, the operation of the general rules of law would be deficient. Okay, deficient in protecting from anticipated wrong or relieving from injuries done. Okay. This is one of the reasons why I chose a petition for a writ of habeas corpus, because this is all me right here. I've been injured. Okay, my son has been injured. Okay, anticipated wrong. If it continues on, it'll continue on. It'll be anticipated, and so this is all me right here. So this is why I need to be in equity. Okay, somebody made a comment in my last video too, saying that We'll go to that video. I'm gonna go to that comment section. I'm kind of addressing them as well. This is not any kind of attack on them. I just want to kind of address what they said. Let me see if I can find it. He said, equity court is not a place where you to get your human rights. Say equity. Hold on a second. Is that what I was trying to say? Say equity court is not the place to get your human rights. Say one must take they put a question mark behind it. So it wasn't a statement, it was a question. I don't know. I don't know. I don't know what they meant by that. It says one must take to a court of inherent jurisdiction. Inherent jurisdiction. I don't even know what they mean by that. I ain't never heard inherent jurisdiction. But I don't even know why I gave that some energy. Because a lot of times when you make comments, y'all have to make sure you don't regurgitate something you heard on another video. Because if you never looked up inherent jurisdiction, come on now, don't make comments like that. Because a lot of times, it lets me know you done heard something from somebody else that you never read. Okay, I never heard of that. But anyway, let's keep moving. Equity jurisdiction. I read this already, so I read that. Let you know this is one of the reasons why I use a petition for a writ of habeas corpus. Now, 4 right here, Article 4. Equity will not take cognizance of a plain legal right where an adequate and complete remedy is provided by law. But the mere privilege of a party to bring an action at law or the existence of a common law remedy not as complete or effectual as equitable relief shall not deprive equity of jurisdiction. So letting you know, this is aligned with that maxim of law. With I guess I'm gonna go over the maxims of law in a minute, but equity is gonna always prevail. Okay, it's gonna always prevail because that's what you and equity is where I think that's where anybody should want to be at, because that's where living men and women are dealing. That's where you're dealing with living man and woman. Okay, that's what they mean by. As a matter of fact, I'm gonna go to this. Let me see. I found this. Let me see if I can back up so you can see where I got this from, what this source is. Back up a little bit. Got this from Oxford. Okay. You can, this is the Oxford reference website. I just typed in maxims of equity or something like that, and you can find it. Click away, you'll find it. I just want to zoom in so y'all can see this a lot closer. Okay, and I'm gonna go over a few of these here. Okay, see if I can zoom in a little bit. Okay, let's see. I want to read some of these. These are some of the maxims right here of equity right here. Matter of fact, I'm gonna start up here at the top. Quick reference. This is just a quick reference. Say short, pithy statements used to denote the general principles that are supposed to run through equity, although often inaccurate and subject to exceptions. They are commonly used to justify particular decisions and express some of the basic principles that have guided the development of equity. The main maxims are as follows: equity acts in personam, equity acts on the conscience, equity aids the vigilant, equity will not suffer a wrong without a remedy. Then they got in i.e. equity will not allow a person who it considers as having a good claim to be denied rights to sue. The right to sue. And okay, equity follows the law. Okay, I like that. Equity follows the law. They say equity follows the rules of common law unless there is a good reason to be contrary. Okay, equity looks at the intent, not at the form. Okay, I want to pause right there because I'm gonna go back to that personam in a minute too, but the intent, not the form, is like it just like it pretty much aligns with the one that says it works on the conscience. Equity acts on the conscience. Okay, what do you believe in your heart to be right? You know what I'm saying? The law may not say what's in your heart to be right, what your intentions are. See right here, the intent, not the form. This is dealing with somebody's conscience. So only a living man can have a conscience. A legal fiction can't have a conscience. Only you can have an intent. The laws. There are loopholes in the law that allows you to do that you can invoke, and it's legal, but it's harmful to somebody else. Okay, so. And they can't get in, and a person can't get in trouble for doing it because it's legal, even though you cause injury to someone else when you did it. You know what I'm saying? So just because it's legal doesn't mean it's equitable. Doesn't mean that it's fair. Okay? Keep in mind, equity deals with what's fair. Okay. Now let's see. I'm actually reading the same thing that's down here, but I'm going to keep on going. Equity looks to the reality of what was intended, rather than the way in which it is expressed. See, this is dealing with somebody's mind. Okay, this is dealing with somebody's mind. A legal fiction can't do that. That's one of the reasons why your petition has to be sworn. It has to be affirmed, or what they call it, verified. Under oath. Only a living man can give an oath. So we know people are the ones that are doing petitions. Fictions are not doing petitions. And when you're doing a petition for a writ of habeas corpus, that's a living man or woman talking. Okay, and that's why it needs to be verified. I always have mine verified with witnesses. Witnesses and a notary, of course. Okay, where the equities are equal, the earlier in time prevails. Remember they talking about first in time, first in line? Okay. Where rights are equal in worth and value, the earlier right takes precedence over the later, the later, whatever you want to call it, is later. Okay. He who seeks equity must do equity. I mentioned this in my last video. In my petition, I wanted to do something. I wanted to make sure the solution that I presented in court was something fair. It wasn't this shit on somebody else's rights just so I can get some get back. You know what I'm saying? I'm not here to be malicious because I want to make sure my son gets what he needs. He needs father and mother in his life. He needs father and mother's provision, nurturing, time spent, quality, the teachings, everything, all the pouring into, he needs it from both sides, not just one. Because then it'd be one sided, and it's not equal to him. It's not equal for him. It's not equitable for him. He who comes to equity must come with clean hands. See equitable remedies. You already know, come with clean hands. Don't come there with some fraudulent intentions and somebody got some dirt on you, and here you are trying to, they got dirt. You already know that you already, you got them dope boys all in your house. You out here, you're a crackhead. You out here selling pussy out the house, and you sitting here trying to see, and it's been proven. It's already documented. It's been proven, and you sitting here trying to use a petition for a writ of habeas corpus so you can try to get some rights invoked, and trying to make like you trying to be as if he don't have a reason to feel why he should, the child, he's, as if, or that go the other way around. Got the dope boys out here trying to fight for their kids, and you know damn well you out here doing this gang shit. Why are you sitting here? Why do you want your child to be in, why do you want custody of your child? Why do you want to be, subject your child into that? Why do you even want to create babies? Here, let's go further than that. Don't stop creating these damn babies like that. Out here in the gang shit. Anyway, let me stick to the topic. Equality is equity. I said this in my last video. That's the root word for it, equal, because you want what is fair. When you're trying to do what's fair, that's what you're trying when you're trying to use equity jurisdiction for. Equity looks on that which that is done what ought to be done. See conversation. See what should have been done in the first place. Off the rip, I would be trying to do 50-50 off the rip. I wouldn't even participate in this child support bullshit, because that does not benefit the child. It does not benefit the father most of the time. We're talking father because most of the time it's the fathers that get hit like that. So anybody who gets locked into a child support case, and they are the ones that have to do all the paying, and they also get their physical rights taken, like their fundamental rights to have physical custody of the child, of the babies, the offspring. You agreeing to that. You're allowing them to take your physical custody and then make you pay for not having physical custody. Come on. That's not equitable at all. It's one-sided, it's unconscionable, it's unfair, it's partial, and they took oaths to be impartial. Okay? It's one of the main reasons I don't have a problem with getting a certified copy of the Constitution and putting in my court case. I would get the oath too, get the oath of office to go with it. But they know they took an oath. So, if you put that Constitution in there, you just make sure you make your petition, make sure it's aligned with equity. Then you can I don't see you not getting a better outcome. Especially you want what's fair. Okay, equity imputes an intent to fulfill an obligation. Okay, let's see. Equity will not assist a volunteer. Okay, now you can't go and put yourself on child support and then you want to go file for a petition for a writ of habeas corpus, and you the one for open up the damn case and you put your own checks up. I'm gonna go put myself on child support. You volunteer. You went in there and bent over for them. So you can't. How you gonna sit here and try to, act like you know what I'm saying? You don't get to do that. I mean, not saying that at some point when you wake your ass up and realize that it was a choice and there was a better way, there's no way out of it, but you get what I'm talking about. So equity is not going to assist you, and you sitting here volunteering to bend over. So if you voluntarily give up your rights, then it's not, nobody going to fight for you. Okay, let me go back to insanum so you understand what equity acts in personam. In personam literally means against the person. Refers to court's power to adjudicate matters directly against the party. Okay, in personam, actually that's directly. Directed against the party. Matters directed against the party. In personam jurisdiction is one of the two forms of personal jurisdiction, with the other being in rem jurisdiction. In rem jurisdiction, which is, it's a legal term describing the power the power a court may exercise over property, either real or personal, or a status against a person over whom the court does not have in personam jurisdiction. Okay. Now, so here we go. Let me go back to what was I? Here we go. So that's what they mean by in personam. Okay. Let me see if there's anything else on here that I did not read. Yeah, I went through all of this. So I just want to let me go to the definitions that I had put to the side. Let's see. Petition. Two definitions, and I'm gonna go in and shut it on down. This ain't gonna be no 45-minute video like it was last time. Okay, I want to show y'all something on so you understand what a petition is as opposed to a regular how the thing is. God damn it! I had the thing set where I wanted it to. I had it set to. So y'all to understand what you need to understand about a petition. Here we go. A petition is a written address, right here, embodying an application or prayer. Keep in mind, it's a prayer from the person, or a prayer is also a request. If you look up prayer, you'll see it's an actual request. Matter of fact, I'm gonna finish reading. Application or prayer from the person or persons preferring it to the power, body, or person to whom it is presented. That would be the judge or whoever it is that fits this, for the exercise of his or their authority in the redress of a wrong of some wrong, or the grant of some favor, privilege, or license. Okay, you ain't got to be trying to get no privilege or no favor, or no privilege or license. Okay, but it says this is or. That's the key word, or. What we dealing with, without say my situation, this is what I'm doing: redress for some wrong. Okay, now let's see. In an application made to a court, an ex parte, or where there are no parties in opposition, praying for the exercise of judicial powers of the court in relation to some matter which is not subject for a suit or action or for authority to do some act which requires the sanction of the court, as for the appointment of a guardian, for leave to sell trust property, etc. That's not my situation. And see, the word petition, it is generally used in judicial proceedings to describe an application in writing in contradistinction to a motion, which may be viva voce. That's what's it. Virgin versus Jones. Let's say the principal distinction between motions and petitions lies in the fact that motions, though usually made in writing, may sometimes be made orally, while a petition is always in writing. Okay. See how I said? Now this is the 1933. This is a third edition Black's Law Dictionary I'm reading this from. So in case y'all kind of wonder. Okay, so a petition is always in writing. Okay. It says so. Also, motions can usually be made only by a party to the record, while petitions may in some cases be presented by persons not parties. Okay, that's Gibbs versus Ewan. I say in the practice of some of the states, the word petition is adopted as the name of that initiatory pleading in an action which is elsewhere called a declaration or complaint. Okay. Equity practice. I'm gonna read this and I'm gonna stop on this part, and I'm gonna go to another word, equity. I think it's equity. I want to read to y'all as well. An application in writing for an order of the court, stating the circumstances upon which it is founded. Say the proceeding resorted to whenever the nature of the application to the court requires a fuller statement than can be conveniently made in a notice of motion. Okay. Now let's see. I'm gonna go back just so y'all understand what a petition versus a motion. And matter of fact, I should have read that part about. Let me see. Something else I wanted to say. Petitioner. See, a petition. Again, by petition against. It was something else I was going to show y'all too. It may not be on this page right here. Let me go and close that one. Okay. I'm gonna go. Well, I'm gonna go there real quick. Let's see, petition. Let's see, is that where I wanted to go? I think that's where I wanted to go. Okay. It was another part. It was something I was reading. Was it in? I'll find it in a second, y'all. Hold it. So we know what petition is. I just wanted. It's supposed to be verified. This is about what it's supposed to be. It says it's supposed to be verified. Matter of fact, I think it was in the codes. Let me see. I think it was in the codes. That's 4. Let's see, was it 3 grounds for? Well, nope. We read that one already. For current contents, where is it? I'm in the wrong spot. A petition. Let's see, petition for. Yeah, here we go. That's what I forgot to do. Here we go. Go back to Habeas Corpus, provisions, contents. There we go. Application for a writ of Habeas Corpus shall be by petition in writing, signed by the applicant, his attorney or agent, or some person in his behalf, and shall state the name, description of the person whose liberty is restrained, the person restraining, the mode of restraint, and the place of detention as nearly as practicable. The cause or pretense of the restraint. If the restraint is under pretense of legal process, let's see, a copy of the process might be, and they're talking about like a court order or whatever. Let's see, a distinct. It don't have to be a court order. Whatever legal process they use or whatever, a copy of the process must be annexed to the petition if this is within the power of the applicant. I'm zooming, y'all, because I'm really looking for something on here. A distinct averment of the alleged legality of the restraint, or of any other reason why the habeas corpus is sought, meaning you're looking for it. okay, and a prayer for the habeas corpus, for the writ of habeas corpus. So that's what the content's supposed to have inside the petition. Let's see. Verification. Here we go. Let's see. To whom is prevented? A petition for a writ of habeas corpus must be verified by oath. That's what I was looking for. Must be verified by the oath of the applicant. So let's say or some other person on his behalf, whoever doing it on your behalf. But if it's you that's doing it, then you got to verify it, okay, on the oath, by the oath. Say it may be, and only a living man can do an oath. Okay, that's why I was looking for this, y'all, because a straw man can't do an oath, cannot verify anything with an oath. Only a living man can do that. It may be presented to the judge of the superior court. Remember, it said it in superior court here in Georgia. That's where equity jurisdiction is invoked. Say of the circuit court in which the illegal detention exists, who may order the party restrained of his liberty to be brought before him from any county in his circuit, or it may be presented to the judge of a probate court of the county, except in cases of capital felonies, or in which a person is held for extradition under warrant of the governor. Okay, that's what I wanted to show y'all, that it had to be verified under oath, by oath. So that's what the petition has to be done. In order for you got the contents of it, what has to be in it, but it also needs to be verified. Okay, only a living man can do an oath. Okay, that's the man or the woman herself or himself that's doing that. So that's how equity. So it lets you know, I'm just kind of helping y'all understand that when you're doing a petition for a writ of habeas corpus, they're not dealing with the straw man. They're dealing with the man, the living man or the living woman who's doing it. Okay, so that's what I wanted to point out to y'all. I want to do one more thing, and I'm gonna go in and shut it on down, and that's gonna be equity. Talking about equity right here. This is the definition of equity: fairness, impartiality. That's one of the words you'll see inside a judge's oath. That they have to be fair and impartial. I be trying to shut it down, y'all, but this is the judge's oath right here. Here we go. This is part of what's in their oath. It's required by law. This is what they have to swear under penalty of perjury. Okay? The oath of a judge. It says the oath of judges, superior court. Before entering on the duties of office, the superior court judges must take an oath required of all civil officers, and in addition, they must take the oath of the following oath. That's the quote right here. That's what they have to say. I swear that I will administer justice without respect to person and do equal rights, equity, equal rights to the poor and the rich, and that I will faithfully and impartially, there we go, discharge and perform all the duties incumbent on me as judge of superior court of this state, according to the best of my ability and understanding, and agreeably to the laws and the Constitution of this state and the Constitution of the United States. So help me God. So whether you got a state constitution or a national constitution, you can still put that in your court case, because they and it speaks in there. It speaks about being impartial in the Constitution. It's part of the Bill of Rights as well. So if you want to put that in there, they have to be fair. That's what impartial means. It means to be fair. Like y'all to see what I'm talking about when I say stuff. I don't like to freestyle and have y'all believe in some stuff that somebody done said. And I like to show. Impartial. As y'all see, this is Black's Law Dictionary, second edition. Impartial. The term used for something unbiased, fair, unprejudiced, straight down the middle. That's equity, y'all. They have to operate in equity. You bring in equity before a judge, and you got that Constitution filed in your court case, and you got an equitable remedy. How can you possibly lose? Okay, because they'll be breaking their oath, and they definitely don't want to. They definitely don't want to get hit for what they call it, perjury. Cause you an oath. If you break an oath, that's perjury, right? You can't swear something under penalty of perjury, saying "So help me God." You can't do an oath like that, and you turn around, you just want to disregard your own oath. So So anyway, I thought I'd put that out there so y'all can understand that. That's why I chose what I chose when I did it this way. When I chose, that's why I recommend a petition for a writ of habeas corpus. And so habeas corpus is not to be slept on. So that's why I thought I'd make this video a part 2, so I can go into deeper details to help you understand more about what I said And I said it was going to be a short video, and I'm still 30 minutes in. Let me get off of here, y'all. Please hit the like and share button. Share this video with, I don't care, Facebook, wherever you share it at. Share it far and wide. And make sure you hit the like button. If you haven't subscribed, please go ahead and do that right now. And I will see y'all in the next video. I got plenty to come. Keep it coming. Okay, let's see if I'm going to think of anything else before I go. I think that's it for now. I'm going to get on off of here. All right, y'all. M. Rose signing out.